Welcome, everyone. Good morning. This is the second of 4 sessions coordinated by the Women's Entrepreneurship Knowledge Hub at Saskatchewan and led by our partners in the community, MLT Atkins. Today, the topic of our discussion will be founder shareholder agreements and governance issues. My name is Gina Grandy, and I am the Dean at the Hill and Levine Schools of Business at University of Regina, and I am the lead for WEKH Saskatchewan. I'm joined today by our panelists and our moderator, but also Amy Pilon, our WEKH Saskatchewan student coordinator. Today and for the next 2 planned sessions, they're intended primarily for women ag entrepreneurs, but we expect the content will be of value to a much wider audience as well. I want to acknowledge that I join you today from the University of Regina, situated on the territories of the Cree, Saulteaux, Dakota, Lakota, Nakota, homeland of the Métis. We have many joining us today from territories across the prairies, so we want to acknowledge the lands you are all joining us from today. We invite you to comment in the chat what territory or land you are joining us from today. I have a couple of reminders before we get started. I'd ask if people can remember that when they're not speaking or when we're not in question period to have your microphone audio muted. We'll have about 30 to 35 minutes for our guest panelists, and then approximately 10 to 15 minutes for questions. If you have questions that emerge along the way, by all means, please feel free to add them to the chat as we go. And then Jody will get to them a little later, or of course you can wait until we actually have the Q&A. You will also have received a notice that we're recording this session, but I just want to remind you that that is happening and the session will be available to share with others following today's event. Our moderator today is Jolie Wildeman from MLT Atkins. And Jody's practice is focused on commercial litigation. She has significant experience working on complex disputes and construction litigation, including large, multifaceted arbitrations. She will be introducing our topic and speakers this morning. Welcome, and thank you, Jody, for leading on this. And I'll now pass it off to your hands to start our panel discussion.
Thanks so much, Gina. We're really pleased to be with you this morning and to be involved in this webinar series. So we have two of our partners from MLT Atkins presenting this morning, and I'll introduce each of them now. We have Erin Boxwin, who is in our Saskatoon office, and Erin assists clients with tax and estate planning issues and general corporate commercial matters. She also has experience dealing with asset and share purchases, corporate governance issues, and unanimous shareholder agreements. Erin is a partner in the firm focused on private enterprise, taxation, and estate planning. She assists clients at all stages of the business cycle, from incorporation to winding up, ensuring that all transactions are undertaken in a tax-efficient manner. Erin provides governance advice to clients, as and is experienced in drafting unanimous shareholder agreements and partnership agreements, which she'll be speaking to some this morning. And our second speaker is Pam Hilderman, who is from our Winnipeg office. Pam practices primarily in the areas of corporate law, commercial law, and securities law, including public offerings and exempt placements, mergers and acquisitions of corporations and assets, startups, joint ventures and transaction structuring, corporate finance takeovers, amalgamations, corporate governance, and shareholders and partnership agreements. So she has a breadth of experience in the areas that she'll be speaking to this morning. She advises clients in various industries and at various stages of development. So with that, I'm going to pass it over to Pam to start to speak about founder shareholder agreements and governance issues in agriculture.
Thank you very much, Jody, and thanks again to WEKH for having us. We're very happy to be here. As Jody mentioned, I work in our Winnipeg office, and I focus on corporate commercial law, mergers and acquisitions, but also have done very many shareholders agreements in my time here. So happy to speak on this today with all of you. Can everyone see the screen okay? The slides?
I can see it well, Pam.
Great, thank you, Jody. Okay, so a few topics we're covering today. As an overview, what's on the slide you'll see is purpose of shareholders agreements, some key issues, governance, as Jody mentioned, majority versus minority shareholder considerations. We'll talk about restrictions on admissions of new shareholders and preemptive rights, restrictions on transfers of shares in a company, shareholder compensation, buy-sell events, shareholder exit mechanisms, offers to purchase, and dispute resolution. The first topic is the purpose of a shareholders agreement, or what is a shareholders agreement. So for those that aren't necessarily familiar with what a shareholders agreement is, it's also often referred to as a unanimous shareholders agreement. The distinction between those two is one where all or not necessarily all of the shareholders of a corporation sign up to this agreement. It's generally an agreement that the shareholders make to regulate how they will operate the business in advance before issues necessarily come up. It's not a required document. It's not a corporate law required document like, say, articles of incorporation would be, but it is strongly recommended, especially where there are multiple shareholders in an organization. And it really provides some parameters around the operation of the business. It's very useful tool when it comes to succession planning and guidance, which is particularly relevant for a lot of our ag clients, where you'll have one generation passing down an operation to the next generation, where, again, it could be some parents that would have made decisions for many years, and suddenly you've got several siblings running the business that won't necessarily be aligned on all matters. You'll see on the slide, we try to avoid a situation like that shown, where in the absence of an agreement, there could be a dispute amongst shareholders or siblings around decisions in the business, and that's where, again, a shareholders agreement really has its value. Many of you are probably aware that a corporation has a board of directors, and that board generally oversees the operations of a business. And it does that with a foundation and what's called fiduciary duties, which generally means acting in the best interests of the corporation. A shareholders agreement, as defined at law, is a document that takes away some of the powers of the board of directors and puts those into the hands of the shareholders, as evidenced by the shareholders agreement. You'll see on the slide that a shareholders agreement is akin to like a rule book for the business, and it can cover as much or as little as the shareholders consider relevant in that business. What I often say to clients when I'm engaged to work on a shareholders agreement for them is that it's something that we hope reflects how you as a shareholder group intends to operate the business in general, regardless of this agreement, and it's filed away and rarely consulted. But we do know in our line of work that it's a very useful tool to have when issues come up, when unique circumstances come up, and we can refer to how the shareholders agreed to handle a situation based on the terms of the shareholders agreement that they agreed to in advance. So on to objectives and key issues. Probably between Erin, my co-presenter, and myself, we've prepared hundreds of shareholders agreements in our time as counsel with MLT Aikens, but I can say that I've never used the same shareholders agreement twice. A shareholder agreement is a very customized document that reflects the specific circumstances of a business and its shareholders and its governance and what the shareholder group really wants to cover in that shareholders agreement. It's particularly relevant, and shareholders agreements really differ just depending on the structure of the shareholders of a group. So if we're 50-50 relationship, it's a very different shareholders agreement than if it was, you know, a group of 10 or more shareholders, or even a group of 3 shareholders. You know, suddenly you don't have an impasse, but you can have a situation where 2 of the 3 outvote the third on various matters. In particular for family businesses as well, they differ. It isn't necessarily the same kind of default concerns that a family business has, but we start bringing into considerations like if we're second generation, if one of the siblings wants to bring in their children in the business, is that entirely their decision? Must they have the consent of their siblings, etc.? So it's a really, again, customized, useful document that is catered to the circumstances of the business to which it relates. Although a shareholders agreement we would typically prepare for a new business in a startup stage, they can really be entered into at any stage of a corporate life cycle. I'm working on a couple right now. One is for an agricultural supply business in rural Manitoba, where there's new investors coming into the business, and the new investors, as a condition to acquiring shares and investing in the business, are requiring that a shareholders agreement be put into place, whereas there had never been a shareholders agreement put in place before, and the founders had just operated without one in place day to day for the past number of years. I'm also working on one for a family succession type business where it's a large, successful Winnipeg-based business. Parents have been running it for many years. It's now transitioning ownership to a group of siblings in the next generation. And again, it brings up a lot of considerations around If one sibling or two siblings want to sell the business, but the others don't, how do we manage that? And Aaron will be discussing some of those dynamics later on in the presentation. We generally approach a new shareholders agreement for a client is by providing a checklist of the things that you should consider for the shareholders agreement and things that you may not have considered for the shareholders agreement, but that are typically included. You'll see on the screen various things that kind of form a foundation of what we would advise on. And that includes what kind of a business does the corporation operate. Of course, if it's an agricultural business, it has likely different considerations than a technology business or a retail business or a different kind of a manufacturing business. What is the relationship amongst the shareholders? Are certain of the shareholders meant to be the operating shareholders and having direct day-to-day involvement in the business, and others are more passive, maybe financial investor shareholders that are only there for their returns in the corporation? Are there any sources of conflict between the shareholders today that we should draft around? For example, is a shareholders agreement being considered because there's issues that have come up and it's really seen as a beneficial tool for resolving disputes as the life cycle of the business continues? Is a shareholder likely to leave, and what are the parameters around that? Again, that comes up in a family business situation where parents that have retired from a business may not necessarily want to stay involved long term. What type of shares do they hold? How are they eventually bought out? How are decisions made at the next generation? Does the business have plans to expand by raising capital, so bringing in new shareholders, and what does that look like, and how do the existing shareholders agree to that? Again, there could be some that would be prepared to take more of a dilutive stake if more shareholders are coming in. Others may not necessarily agree, so we provide some parameters around how those decisions are made. Whether or not shareholders are commercially or legally sophisticated in these types of agreements is also relevant. As an aside, one of the things we typically require is that because a shareholders agreement is a company agreement, but represents the interests of the various shareholders in that business, will require that the individual shareholders also have independent legal advice. Unlike directors that have that fiduciary duty to act in the best interests of a corporation, shareholders wearing their shareholder hat are allowed to be self-interested and look out for their own best interests as shareholders. So if company counsel, we were acting for a company, for example, was drafting the shareholders agreement, it would be appropriate for the individual shareholders to have independent legal counsel as well to advise them based on their own specific shareholder interests. And we've also flagged, do any of the shareholders own another business? And if so, how does that relate to the business to which the shareholders agreement relates? Do those businesses transact together, and how are those transactions approved if there's a perceived conflict of interest, perhaps? We'll also provide some various hypotheticals, which Aaron will speak to later, around succession and triggering events that could require a shareholder to dispose of their shares. What happens, for example, if a key shareholder dies or becomes disabled, or a shareholder defaults under the terms of the agreement, and Aaron will talk about that later. At a high level, I would say the shareholders agreements we prepare typically focus on three broad areas: governance, compensation for shareholders, and buy-sell events. With respect to shareholders having competing interests on these topics, it could be minority and majority shareholders that have a differing view. It could be shareholders generally that have a differing view if they're equal, say 33% shareholders, 3 of them, or 50-50 shareholders. We will have various exit circumstances that we'll review again later as well. With respect to governance issues, as mentioned earlier, a shareholders agreement really serves to take power away from the board of directors that would otherwise oversee a corporation. Corporate law we can consider as paramount. That's something that can't be drafted around or contracted around. The Corporations Act of Manitoba, for example, which is quite common in my practice here in Winnipeg, sets out rules for how a business must operate, but various provisions of the Corporations Act will say language to the effect of subject to what shareholders might agree to in a shareholders agreement. This is the process that must be followed in this kind of a circumstance. So again, the law, even though it can't be contracted around, specifically provides for the ability of shareholders to agree otherwise in a shareholders agreement in some situations. The slide shows generally default rules for corporate governance, which is general oversight of the board, and the law distinguishing some shareholder consequences that are so important that shareholders are inserted into the decision-making process and that decision is taken away from the board. An example that we flagged is if a business is selling all of its assets. As a shareholder, you certainly would want to have some right to approve that type of a transaction because it effectively absolves your interest in the business to some kind of a cash position as opposed to a going concern business. Similarly, things like changing the rights of the shares held by a shareholder requires special shareholder approval if you hold voting shares, and there's a proposal to change the rights attached to those shares. As non-voting shares, of course, as the shareholder, you would want to have an ability to approve that or disapprove that. Beyond what the law identifies as fundamental items, shareholders agreement can identify other areas that shareholders can control. And we've got various examples on the slide again. Things like repayment of a shareholder loan. If a shareholder loan is in place, the terms around when that is repaid, or if it's prepaid early, that can be flagged as something requiring consent of a certain percentage of shareholders. Same with issuing shares, same with declaring dividends, same with establishing compensation for directors, officers, and shareholders, or even highly compensated employees to the extent that that triggers a materiality threshold. The shareholders might very well want to have an ability to consent to that and not leave that to the board or management of a company. Approving capital expenditures beyond a certain amount is a very common clause that requires special shareholder approval of a certain percent of shareholders as well, or entering into contracts over a certain value. Borrowing powers is often included in a shareholders agreement. For example, if a shareholder requires financing, must the corporation only seek bank financing? Can the shareholders be cash called such that the shareholders are forced to contribute their own resources to financing the company? And if that is required, what happens, for example, if one shareholder does and one shareholder doesn't? And a shareholders agreement will have various ways to draft around that and manage that potential situation. And it's often dealt with a preferential right to say dividends to the shareholder that's contributed while another shareholder hasn't. Redemptions is flagged as well, and of course, fundamental corporate transactions like an amalgamation or dissolving, winding up the corporation, a shareholder would typically want to have some say in that decision as well. The shareholders agreement will serve to also increase in many times the percentage of shareholders that must consent to a certain transaction. And again, corporate law, the default is typically 2/3. That's seen as a critical mass in terms of shareholder approval for a very fundamental item like selling the business. But a shareholders agreement can say, for example, if we've got a 4-shareholder group, that our critical mass is 75% instead of what the corporate law would require, or whichever percentage makes sense based on the circumstances of the business. There are unique ways, I would say, to deal with a 50-50 shareholder relationship. It's not always conducive for unanimity, say in a 50-50 shareholder relationship, where one shareholder can always have a veto power on the other shareholder for any decision that comes up, especially if that stalls the operations of the business. So a shareholders agreement will often provide some workarounds for ensuring that the business can continue even if shareholders are at an impasse or just generally aren't getting along. Matters impacting how the board of directors itself are comprised and governed are often included as well. The directors again serve at what we call the pleasure of the shareholders, meaning the shareholders appoint the directors typically every year or for whatever term that they've been appointed for. Directors are required to exercise their fiduciary duties in operating the business and overseeing the business, but the composition of the board is very commonly included in a shareholders agreement. So say a 3-shareholder company, each of those 3 shareholders might want the right to nominate a specific director to the board with a board comprised of 3 directors. And it's very often in a situation where the shareholders are individuals that the individual shareholder also takes on the board seat. And the shareholders agreement would require that the other shareholders vote for their nominee because that's their contractual right to appoint whichever nominee they like. Similarly, shareholders agreement often includes terms around a shareholder's right to review and be provided with financial statements outside of the default, which is generally annual financial statements of a corporation. It's quite common, for example, for a shareholders agreement to indicate that shareholders are entitled to quarterly or monthly financial statements as those are prepared. And the last topic I'll touch on for the moment is shareholder compensation issues. This really ties to if a shareholder invests in a business, what return on that investment, if any, can that shareholder bargain for? So you can consider compensation in 3 ways. One, compensation of shareholders as employees, potentially shareholders as directors, and shareholders in their capacity as shareholders. And even often if that's the same individual, they can be considered as wearing 3 separate hats with separate rights. So if a shareholder is an employee, that employee is typically entitled to fair market compensation, regardless of the fact that they are an employee. So if the shareholder is the president, for example, what is the salary of the president? How is that set? That's often included in the shareholders agreement as something that must be agreed to by a certain percentage of the shareholders. Similarly, the shareholders taking on role as board members might bargain for board of director fees. And that would again be something that could be set by a certain percentage of shareholders or a compensation committee that is struck with a subset of directors or others. And lastly, shareholders in their capacities as shareholders. If you're a shareholder, your return is often by way of dividends. So does your shareholders agreement include a dividend policy that speaks to when the company will declare dividends? Will the company reinvest all of its profits in the business? What does that look like? The shareholders can agree to that kind of a situation in advance. Shareholders might also count on some of their shares, if they're redeemable, being redeemed over time. And if there's a right within the corporation's articles to redeem shares, who makes the decision to redeem those shares and pay out the shareholders? So again, a high-level overview of many of the most common areas we see on the governance and compensation and structuring side of a shareholders agreement. I'll turn it over to Erin now to speak to the topic of bringing on new shareholders in a business.
Great. Thanks, Pam. I just switched over to my slide deck. Can someone just confirm, Pam, can you confirm you can see it?
I can, yeah, thanks.
Okay, great. So the portion of my presentation is going to focus on a few different topics. The first one I wanted to speak about today is restriction on admission of new shareholders. See if I can get technology to work with me here. There we go. So this is a common feature of most shareholder agreements, and the thinking behind this type of clause is if I'm in a privately held company with 2 or 3 or even 12 other people, I probably don't want to be forced into business and forced into owning a company with some unknown third party. Balance that against, though, the fact that the corporation itself may want or need the flexibility to raise capital in the future. So one way to accomplish both of these goals is to have a general restriction on the ability of the corporation to issue new shares to new shareholders. but to couple that with what we call a preemptive rights clause. So a preemptive rights clause says that the board of directors can determine that there's a need to raise additional capital, and they would notify the shareholders of, say, the desire to raise $2 million of capital. And if the existing shareholders want to participate in that capital raise, then they have the first opportunity to participate on a pro rata basis so that they can avoid dilution of their shares in the company. But if the existing shareholders decide that they're going to decline to participate, so they decline the preemptive right, and they do not fully subscribe for, in my example, the full $2 million worth of capital raise, then the corporation has the right to go out and try and raise that capital from other shareholders and third parties, and the existing shareholders do not have the ability to prevent the admission of new shareholders. So the idea behind this type of restriction in agreement is that it gives the shareholders, the existing shareholders, the ability to avoid dilution and to have a say in avoiding new shareholders entering the company, but at the same time ensures that the corporation itself is not constrained in terms of its ability to raise capital. So the next section I want to talk about is restrictions on the transfer of shares. So again, typically there's a desire in a privately held company to avoid or preclude the ability of shareholders from transferring their shares to unknown third parties for many of the same reasons I gave earlier when I was discussing new shareholders just subscribing for new shares in the company. So while there is this desire to prevent unknown third parties from coming in, there is, again, a competing tension where shareholders might say, well, there may be a circumstance in which I want to leave the corporation. And so there's some ability, some desire to kind of preserve that ability to sell shares and provide a liquid market for the shares in the event that a shareholder wants to depart. So to deal with this, most shareholder agreements will usually contain a general prohibition on the ability of shareholders to transfer their shares to third parties unless a couple of circumstances are satisfied. So very commonly, first, there will be a requirement for board approval for any transfer of shares. But there can also be a second procedural step that's layered on top of that that has to be complied with before a shareholder can sell their shares to a third party. And one of the most common procedural steps you'll see complied with that are required to be complied with would be a right of first refusal, where you'll sometimes see that referred to or called a ROFR right. So what that means is if a shareholder who is in the company receives an offer to purchase his or her shares, and the shareholder wants to accept that offer, the shareholder would present the offer that they received to all of their other shareholders and say, I'm prepared to accept this offer, but if you are willing to pay the price set out in this offer and accept the same terms, then you can exercise your right of first refusal and I'll sell to you instead of selling to this third party. And if none of the existing shareholders exercise that right of first refusal, then the shareholder who is wanting to sell their shares can freely go ahead and sell their shares to that third party. These right of first refusal or ROFR clauses are really common, and they're a good way for shareholders to ensure that they have control over who comes into the company, while still preserving the potential liquid market for a shareholder if they do want to depart. The one thing I guess I will say is shareholders need to be mindful that as soon as you insert a right of first refusal clause into your agreement, you can be still, well, your desire is to preserve marketability and liquidity for your shares, you're very likely reducing the marketability of your shares. And if you think about it, the reason why I say that is if you own shares in a company and you want to sell them to a third party, and the third party finds out that these shares are subject to a right of first refusal, it's possible that they're going to say, look, I'm less interested in spending time and effort and doing due diligence on your company, or spending legal dollars drafting up an offer or a letter of intent or a purchase agreement, when I know that I might make this offer to you, and then you're going to take it to your other shareholders and they're just going to scoop it up by exercising their right of first refusal. So, something to keep in mind, because it can impact marketability, or if you are wanting to get around that, then when you want to go and sell your shares, you probably have to deal with that right of first refusal clause up front to give third parties some comfort that your fellow shareholders aren't going to be exercising their right of first refusal. And the reality is, when you're talking about a privately held company, there's already a pretty limited market for a partial interest in a closely held company. Usually, if the company is to be sold, the buyer is wanting to purchase the whole thing. So I would say in most of the shareholder agreements I have drafted, the parties weigh it and determine that they still do want to include the right of first refusal clause, notwithstanding any potential impact on marketability. The other way of structuring this, or another type of clause that can be utilized, particularly if there are some concerns around that marketability concept I referred to earlier, is a right of first offer. So what a right of first offer clause says is, if you're a shareholder and you are looking to go out and sell your stake in the corporation, before you go out and you try and find a buyer, you need to go first to your fellow shareholders and give them the option to buy your stake, or at least engage with them and give them the first chance to make you an offer. So it's not a right of first refusal, because remember, a right of first refusal assumes that you have a third party who's already made an offer to purchase. So a right of first refusal is sort of predicated on the assumption that you have a third party or an offerer waiting in the wings. Whereas the right of first offer is just saying, if you are going to try and go out and sell your shares, come to us first before you start negotiations with other third parties. Oops. So the next set of slides I want to talk about are some buy-sell events. And again, these are really common typical provisions you'll see in a shareholder agreement. And there are a few different types of buy-sell events that you'll often see, and I sort of divide them in my head into two categories. So the first category of events are what I would refer to as non-fault type buyout events. So, and as an example, you may have buy-sell events that are triggered in the event a shareholder dies or becomes disabled. And then there's a whole other bucket of types of events that I think of as fault buyout events. And I characterize them like that because they are something, unlike death or disability, that is actually in the control of the shareholder, or there's something that the shareholder has done that has caused the event to be triggered. So some examples, and I put a few up on the slide, are things like a shareholder going bankrupt or becoming insolvent, or a shareholder having their shares seized by a creditor, or having them seized by an estranged spouse in the context of a family property proceeding. The shareholder who works for the company being terminated for cause, or just an outright material breach of the agreement by another shareholder. And these are just examples. There's a whole bunch of other types of what I'll call fault-based events that parties will put into their agreement that will trigger potentially buy-sell events. And depending on how the agreement is drafted and the particular circumstances you're dealing with, sometimes you'll see that when a specific event happens, there's a mandatory buyout. And in other cases, it's left as being optional. So just to give an example, death is a common event where there is a mandatory buyout of shares, which is designed to, A, get that shareholder out of the company. If they're deceased, you don't necessarily want the executor of their estate or their beneficiary to sort of continue on holding those shares in the company, but also achieves liquidity for the deceased shareholder's estate so that they their stake in the company can be turned into cash and distributed to beneficiaries. But in the case of bankruptcy, for example, the obligation to purchase may be optional, because if someone has done something on what I'll call a fault-based event, it's not necessarily the case that you want to give them liquidity. It may not be a very good time for the other shareholders or the company to come up with the cash to buy them out. So the other thing you'll see, just kind of connected to what I was just describing, is who actually has that obligation to that mandatory obligation to purchase the shares, or that option to purchase the shares, can actually differ depending on how the agreement is drafted. So it could be that the corporation has the obligation to repurchase the shareholder shares, or it could be one or more or all of the other shareholders who have that right or obligation. And that is something that really does need to be carefully considered for a couple different reasons. First, if it's going to be the corporation that purchases the shares, you're using corporate dollars to fund the buyout, which effectively means that the entire group is funding the repurchase, and their shareholdings will increase proportionately after the repurchase is completed, because you're just removing someone from the company. In contrast, if the option or the obligation is placed on the co-shareholders, then each shareholder would be funding that purchase event using their own dollars, and they will increase their shareholdings and their proportionate share in the company based on the number of shares that they actually fund and purchase. And secondly, there are actually very different tax consequences that flow depending on whether the purchaser is the corporation or whether another shareholder is the purchaser. And that difference in tax can actually be quite significant. So it's certainly worth thinking about when you are drafting your shareholder agreement. The other thing that needs to be kept in mind when you're structuring the buy-sell events is how you actually assess the terms that will be applicable. So one of the most important terms that needs to be assessed is, well, if there's going to be a buyout of shares, what's the price? And you may have valuation provisions in your agreement that require the shares to be valued by a third party, or you may have a pre-agreed formula that sets out how the purchase price is calculated. But typically there will be some mechanism for determining what is the price on a buyout. You'll also often see that when there is what I referred to before as fault events, so things like bankruptcy or breach of the agreement, there may be a discount on the purchase price that would otherwise be determined under the agreement. So the parties may say, well, if you die or become disabled, I'm willing to pay you fair market value, 100 cents on the dollar to repurchase your shares. But if you've breached the agreement in a material way, or you've gone bankrupt, or whatever it might be, I may only be prepared to pay you 50 cents on the dollar. So 50% of fair market value, or 75%, or whatever the parties come to a conclusion on. Before I go on, I guess the agreement should also, prescribe the specific terms that will apply on the sale. So typically we would set out things like, will the purchase price be paid on closing in full, or will it be paid out over a number of years? And if it is to be paid out over a number of years, is there security that's granted to the departing shareholder in respect of the balance of the unpaid purchase price? It would also talk about things like, well, if you leave as a shareholder of the company, do you have to resign as an employee, a director, an officer, or can you continue working for the company even though you don't hold a stake in it anymore? The agreement may also include things like non-competition covenants, so whether or not the shareholder can go and set up a competing business down the street. Non-solicitation covenants, so restrictions on the ability of the departing shareholder to solicit existing customers or clients, or perhaps to solicit away key employees. Or there may be confidentiality obligations on the shareholder after they depart the company. We also would typically deal with things like the shareholder loans that are owed by the shareholder to the corporation, or by the corporation to the shareholder. and get that cleaned up as part of the departure of the shareholder from the company. And also look to release any guarantees, because oftentimes shareholders may have provided personal guarantees of the corporation's debt, and they simply don't want to be on the hook for those guarantees anymore if they're no longer a shareholder in the company. You'll also see in shareholder agreements other specific types of exit mechanisms that are designed to allow what I would call a corporate divorce. So I will kind of cover a few of them here. One clause you'll often see parties talk about at the time they're drafting a shareholder agreement is a shotgun clause. So a shotgun clause basically says, if one shareholder wants to trigger the shotgun clause, they deliver an offer to the other shareholder saying, I want to sell my shares to you at a price of, call it $10 per share or whatever it might be. And here are the terms. And the shareholder receiving that offer either says, okay, I will buy your shares at $10 per share on the terms you've set out, or they can turn it around and say, no, I'm not interested in buying you out, but I will have you buy my shares at that price and on those terms and conditions. So effectively, once the shotgun is triggered, one of the shareholders is leaving, either the shareholder who triggered the shotgun clause or the other shareholder who the shotgun clause offer was made to. And the price in which that shareholder is departing is what is set out in the shotgun offer. And the idea behind this clause is that it leads to fairness, because when you make that shotgun offer, you don't know if you're going to be the purchaser or the vendor. And so as a result, the theory is that you will choose a fair price because you don't know which side of the transaction you're going to be on. That's the theory behind it. One of the problems with the shotgun clause, if you're looking at putting this into your agreement, is that if there's any inequality between the parties, it can, notwithstanding the theory of fairness, lead to unfair results. So as an example, if you have two shareholders, one who has very deep pockets, a lot of assets, a lot of wealth, and one who does not, you can see how the shareholder with deep pockets could take advantage of the shareholder who has less resources by making a shotgun offer that sets out a purchase price that's a deep discount on the shares. So if I'm the wealthy shareholder, I say to you, I'm going to buy your shares for this deep discount amount. And I know that you don't have liquidity or assets or resources or access to financing. And so even though you think that's a very poor price and a very low, deep discount price, if you don't have the resources to be able to turn it around on me, I will force you to sell your shares to me at a deep discount. Another example would be if you have one shareholder who's active in the business and the other shareholder who's not. The shareholder who is active in the business kind of knows that if they make a shotgun offer, it's very unlikely that it'll be turned around on them, where the inactive shareholder will actually choose to buy them out because the inactive shareholder may not know the first thing about how to run the business. So again, that's another circumstance that can lead to inequalities. So if you're looking at putting one of these clauses into your agreement, definitely suggest you obtain some advice and think through those scenarios about, well, is this a circumstance where there could be some inequality that flows out of the shotgun? And if so, am I on the benefiting or the detrimenting side of that potential inequality? The next set of clauses I want to talk about are piggyback and drag-along rights. So these clauses are designed to apply when there's a third party who is looking to purchase shares in the corporation. So the piggyback or tag-along rights are typically a provision that protect the minority shareholder. So it basically says if the majority shareholder receives an offer to purchase their shares, the minority shareholder can say, hold on, majority shareholder, you cannot sell your shares to this outside third party unless you get me an offer on those exact same terms and conditions to sell my minority stake for the same price to that third party. So I want to tag along on the sale that you have cooked up with this third party. The converse to that piggyback right is the drag along. And typically if you have piggyback rights, you have drag along. They kind of go together. And the drag along right is the kind of converse that's granted to the majority shareholder, which says, well, if the shareholders have received an offer to purchase the whole company, and the majority shareholder is interested in selling the company to this third party, but the minority shareholder doesn't want to accept, they're holding out, the majority shareholder can actually drag the minority shareholder along on the purchase and force them to sell their shares to the third party on the offer that was received. And the idea behind this clause is that, as I alluded to earlier, most third parties are not interested in purchasing just a majority stake in the company and have a sort of lingering minority shareholder left behind. They want to buy the whole thing or nothing at all. And so if you have a buyer who says, I want to buy the whole company, and you have this minority shareholder who's holding up a very good offer and they're just holding out, the drag along would allow the majority shareholder to just drag the minority shareholder along on that purchase and force them to sell. So the last set of provisions I want to speak to is dispute resolution. So from a legal perspective and our perspective as counsel, we know that disputes happen between shareholders. And these can be minor disputes that happen day to day that your legal advisors never get involved in, or they can be disputes that rise to a more material matter. And ultimately, we've seen those types of shareholders disputes end up in litigation before a court that can cost the company thousands or even $1 million in legal fees in the most extreme situation. So given that, and given the potential for disputes, the ideal situation is for the shareholder agreement to provide some type of self-help dispute resolution to deal with those disputes when they arise, so that you don't end up having to call me or having to call Pam or having to call one of the litigators like Jody at our office. And you can deal with that dispute based on the dispute resolution mechanism that is set out in the agreement. And given where we're at for time, I won't go into detail on the types of dispute resolution clauses you could have. And I guess I would just recommend that you do have some type of dispute resolution concept in your agreement and try and set out a process so that you can avoid litigation down the road. So with that, we have just about 10 minutes left for questions. So I'm going to stop sharing my screen so that you can see both Pam and I. And happy to take any questions that you may have. I don't know, Pam, if you've been monitoring the chat and want to deal with any of the ones that are there already, or I can quickly kind of breeze through it as well.
Sure. One came in around the usefulness of shareholders agreement for not-for-profit corporations. Mm-hmm. You might have a view on this as well, Erin, from a more tax perspective, but generally shareholders agreements are designed for share capital corporations, which not-for-profits are not. They're non-share capital, meaning they have members and not shareholders. Depending, I would say, on the type of not-for-profit, there's some statutes that allow for effectively unanimous members agreement, which has some similarity. But we would have to take a look at under which corporate statute, for example, the not-for-profit has been established and help that way. If it relates really to the fact that there was a note that some employees are being engaged by the not-for-profit, your best protection there is probably a strong written employment agreement with the employees to govern the terms of their employment, and the members on behalf of the not-for-profit would agree to the terms of that employment agreement before it is signed by the not-for-profit as the employer.
Yeah, I agree with that comment, Pam. I do some work in the nonprofit context, and it is not typical, I would say, for there to be unanimous member agreements, although like Pam alluded to, it is possible. But because nonprofits, the membership interest it's a little bit different, even though they're in similar role like shareholders, in the sense that members like shareholders elect the board. Members don't have that same profit-making motivation, so they don't have the entitlement to receive dividends, and typically their membership interest doesn't increase in value the same way that someone's shareholdings do. So the considerations, if there is going to be a unanimous members agreement, are a lot different, and typically they're more kind of around securing rights to appoint the board. So you may have different member groups that enter into some type of voting agreement to control who gets to sit on the board of the nonprofit, but a lot of the things we're talking about here would not necessarily be applicable in the nonprofit context. I see there's another one that's come in here now on family trusts. So this might be, the question is, can a family trust be included in the shareholder agreement if the trust holds voting shares but not equity? The answer to that question is yes. It's possible for any shareholder, regardless of the type of shares that they own, to be included in a shareholder agreement. And if the family trust owns voting shares, that's actually a very good reason for them to be included in the shareholder agreement, because they have votes and the other shareholders may wish to constrain the manner in which they're exercising those votes, as an example.
And I would just add to that, it's quite common, because family trusts are a good tax planning tool and have some other benefits. So it's quite common for trusts to be party to shareholders agreement in their capacity as a shareholder.
Yes, absolutely.
That may be it for questions. Both Erin and I are, of course, very happy to help with any questions that come up after the seminar today. I think you'll have our contact information from the top of the slides, but we're quite easy to find online through MLT Aikens as well.
That's my cue, I think, to come back in. I want to thank Erin and Pam, as well as Jody, for being here today and for sharing with us your expert knowledge. I suspect there may very well be additional questions. You did give very thorough presentations, but again, I would remind people that as you've offered, if you have additional questions for Erin or Pam, please reach out to them. So again, I want to thank our panelists. I want to thank MLT Atkins, incredibly appreciated from our side. Also want to thank Amy Pilon for her behind the scenes work to make this happen. And of course, I want to thank all of you today for joining us. Our next session is on intellectual property, protecting your agricultural brand, which I'm sure will also prove to be an interesting conversation. It's occurring on March 10th from 11 till 12 p.m. And I know that the registration is now already open. So I would encourage you to consider joining us for that session. But also, if you know others who may have an interest in it, by all means. And I'm assuming, Amy, that those people who attend today have now been added to our list so that they will get notices. So that's great. Again, I want to thank everyone for joining us today. It's been a great session. Enjoy the rest of your day, and we will hopefully see you all again on March 10th. Bye, everyone, and thanks.